The Supreme Court on Monday said it will decide whether President Trump can fire members of the Federal Trade Commission without cause, taking up a dispute that tests the president's removal power and could weaken protections enacted by Congress that aim to insulate independent agencies from political pressure. So a bit of context for the way the FTC is supposed to be structured, right? The FTC, the Federal Trade Commission, is headed by 5 commissioners, and the rules state that no more than 3 of these commissioners at a time are supposed to be from the same political party. So this is to ensure a bit of a bipartisanness and to ensure that the commission doesn't become completely partisan in one way or the other. And there is a very clear rule with regards to the firing and changing of commissioners. And it says that commissioners serve 7-year terms and by law can only be fired for, quote, inefficiency, neglect of duty, or malfeasance in office, end quote. So the terms by which you would be fired you could be fired as an FTC commissioner are very clear and very spelled out very directly in the FTC's founding documents in the document, fleshing out their mandate and whatnot. The High Court said in a brief order that it will allow Mr. Trump to fire Rebecca Kelly Slaughter from her position at the FTC while it considers the case. It will hear arguments in its December session, and its stay will remain in place until it issues a decision. Justices Elena Kagan, Sonia Sotomayor, and Ketanji Brown Jackson dissented from the majority's decision to allow Slaughter's removal. The justices will consider whether removal protections it should be pretty obvious, to anybody who's paying attention or just listened to what I said about the way that the commission is structured, right? It is very deliberately structured in a way to ensure that it is not corrupted, to ensure that it is not taken over by one political side and used as a tool against the other. Well, it seems very clear in that the founding documents of it, and that I just laid out the rules regarding its makeup and the firing and hiring of the commissioners makes it very clear the intention of this agency, right? It's very clear it's intended to be an independent, bipartisan, oversight type of agency, not something to be used as a political cudgel. The justices will consider whether removal protections for members of the FTC violate the separations of powers and, if so, whether its 1935 decision that allowed Congress to impose removal protections for officials at independent agencies should be overturned. It will also weigh whether a federal court can prevent a person's removal from public office, as U.S. district courts have been doing in challenges stemming from Mr. Trump's firing of Democratic appointees. So to translate this into English for y'all, the justices are basically trying to argue that, technically because this agency falls under the purview of the executive branch and that the president is the head of the executive branch, that nothing else matters, that the intention of the creation of the agency doesn't matter, the rules with regards to the laws and bills that directly affect the agency and control how it's supposed to act and its mandate and whatnot don't, and the overall ethos and intention of the agency in the first place, none of that matters at all within the context of it being under the purview of the executive branch and that being under the purview of the president. Now, if they did this, it would be a huge problem because it would implicate literally all federal agencies that exist, right? Because all federal agencies, as far as I understand, are technically under the purview of the executive, right? But think about it. What is a federal agency in and of itself? Well, Congress, in theory, has a humongous amount of duties, right? If we didn't have any agencies, if you took the EPA, for instance, right? The EPA is in charge of setting certain emission standards, saying you can't pollute above a certain amount of CO2 per cubic meter in your factory or something along those lines, right? Well, if we didn't have the EPA, then it would be up to Congress every single time we got new science that indicated, maybe we should change the threshold. We should increase the threshold or decrease the threshold, or maybe we should or shouldn't allow this specific chemical to be dumped in this waterway or not. Congress themselves, all of them, would have to come forward and vote on that specific technical thing every single time there was a change that would need to be occurred, right? And one way to think about it is people in Congress, for the most part, are generalists, right? That's how I've heard it described, right? They have a general understanding and sort of a surface level understanding of basically all issues, but they aren't a true subject matter expert on any of them, really, right? They're like a jack of all trades, master of none sort of thing. Now, some people in Congress are a bit more specialist than others and do have some technical information that might be, applicable to certain individual things. But for the most part, most of Congress are generalists. And with this understanding, it would be unrealistic for them to expect them to be able to handle all of their congressional duties and all of the bills that you would want to pass on a yearly basis and update every single bill with, like I said, with the EPA and their changes to science and emission standards and whatnot, right? The Congress themselves would have to go in and vote on this every single time. And that's just not realistic because of what I said, because they're generalists. So what did they do to sort of rectify this inherent problem with the way the government is structured? Well, they said, okay, we're going to delegate some of our powers to these agencies. We're going to create the EPA and say, look, we're going to delegate some of our environmental protection authority powers over to this agency so you guys can handle it. So you guys can be staffed with career subject matter experts, people who have PhDs in this, who study this for a living, who understand very, very thoroughly where that line should be drawn, where, what new rules should be in place and what rules should be removed and whatnot. And that seems like it works really well, right? It keeps Congress's duties on this independent from political action, right? It keeps them independent from any of these agencies. In theory are supposed to be independent from political influence of whoever happens to be president at the time or whoever, holds the majority in Congress at the time. But what the Supreme Court is flirting with here is basically a throwing out of that entire system, literally a chucking out of the entire concept of delegating congressional power to executive agencies for convenience, for efficiency, for whatever verb you want to use, right? They're basically flirting with the idea of throwing that entirely out. And that would be hugely problematic because then it would put the onus back on Congress to actually update all of these bills and every single thing. And also it leaves these agencies susceptible to being political tools, to being biased in one way or the other based on who's the president at the time or who has the majority in Congress. And so it seems like, in my estimation, it would be very detrimental to the country in general, to our functioning as a government in the United States and our hegemony and whatnot, if we were to remove this would be the removal of agencies, executive agencies' independence from overt top-down total control of the head of the executive, which is the president. In her dissent, Kagan wrote that the Supreme Court has handed full control of certain independent agencies that Congress has sought to shield from political pressure to the president. He may now remove, so says the majority, though Congress said differently, any member he wishes for any reason or no reason at all, and he may thereby extinguish the agency's bipartisanship and independence, she said. Now, one thing that I just keep coming back to is well, if they allow this to happen and then they officially overturn this rule and then Trump goes completely buck wild and starts stacking all of these agencies as maximally as possible to his political side, you know what the Democrats have to do? It's not a matter of opinion. It's not a matter of oh, I'm being overly aggressive on the strategy or whatever. No, they objectively, by any serious metagame, game theory analysis of the situation, they absolutely have to use this to their advantage. And the next time they take office, they would have to swing all these agencies back into their favor. And I would say not only do that, but try and go a step further and do what they possibly could to lock down these agencies in their favor, something that I'm sure the Republicans would be more than willing to do or more than wanting to do in this kind of scenario. Now, am I holding my breath that they're going to do any of this? Absolutely not. The Democrats are feckless. Their leadership is way too old, way too stuck in the mud, and way too beholden to procedure and to they've watched too much of the West Wing TV show, and they have a fundamental misunderstanding about how government works in the year 2025. The dispute arose out of Mr. Trump's move to oust Slaughter from her position on the FTC. A lower court found that the president's attempt to fire Slaughter violated a 1914 law that limits the grounds for removing an FTC commissioner to instances of inefficiency, neglect of duty, or malfeasance in office, and ordered her to be reinstated. That's the thing that I brought up at the very beginning of all of this, that that is the exact wording by which, in theory, they are supposed to be allowed to be fired or rehired or whatnot. Earlier this month, Chief Justice John Roberts had temporarily paused that lower court order blocking Slaughter's firing while the Supreme Court considered whether to grant the Trump administration's emergency relief. In its emergency appeal to the High Court, the Trump administration urged the justices to swiftly evaluate the constitutionality of the removal restrictions for the FTC before the appeals court has weighed in. Lawyers for Slaughter agreed that the question of whether the protections violate the separations of powers is ripe for the Supreme Court's consideration. The case is the latest in a string of emergency appeals that arrived before the Supreme Court in response to Mr. Trump's efforts to fire Democratic-appointed members of independent agencies at will. The conservative justices, it should go without saying this article hasn't laid it out clearly, but he is trying to fire only the Democratic members of that commission, right? It's not like he's trying to dismantle the commission and saying that I should have that, that authority or something. He's saying, no, I recognize the existence of the commission. I recognize the the commission's authority in all these matters, but I don't recognize that it's supposed to be bipartisan. I don't recognize that the rules say that, and I want to just stack it in my favor because I can, because you guys aren't going to do anything about it, and I have a Supreme Court that's going to support me on this, or very well will likely support me on this. The conservative justices have endorsed the president's removal authority so far, clearing the way for Mr. Trump to fire without cause members of the National Labor Relations Board, Merit Systems Protection Board, and Consumer Product Safety Commission, despite federal laws protecting them from being removed at will. Those decisions have called into question the future of the 90-year-old precedent that upheld removal protections enacted by Congress for members of the FTC, the same body on which Slaughter served. In its 1935 decision in the case Humphrey's Executor v. United States, the Supreme Court said Congress could shield certain officials from being removed by the president without cause, which seems like a super important aspect to the proper and efficient functioning of these government agencies, which I feel like I've already established in earlier parts of this commentary, that is very important to a properly, efficiently functioning government in the year 2025, because it's unrealistic to expect Congress to take up all of the duties that the agencies currently have. And yes, my understanding is that the precedent, the Supreme Court legal precedent, that has been the case for about 100 years, and that the Supreme Court is seriously looking to overturn, which would give Trump, exclusive control over all of these executive agencies, is called Humphrey's Executor. Lower courts have relied on Humphrey's Executor as grounds for reinstating officials whom Mr. Trump has attempted to fire. But the steady stream of those decisions prompted calls for the Supreme Court to definitively decide whether the president has the authority to fire the leaders of independent agencies that Congress has insulated from political shifts. In a concurring opinion in a case involving the removal of 3 members of the Consumer Product Safety Commission, Justice Brett Kavanaugh warned that the downsides of delay in definitively resolving the status of the precedent sometimes tend to outweigh the benefits of further lower court consideration, end quote. Mr. Trump appointed Slaughter to the FTC in 2018, and former President Joe Biden reappointed her to a second term expiring in 2029. Okay, so wait, this was an original Trump appointee? So Trump appointed this Slaughter lady to the FTC in 2018, so it's not like, wait. So he's trying, that makes this all even weirder and funnier, right? Because it shows just how much he's lost his damn mind since the first term, okay? That he's wanting to fire this, that he's making a huge stink about firing the same lady that he appointed in 2018. But I guess in his eyes, as soon as Joe Biden reappointed her, she becomes an entirely different person. She might as well be the devil at that point. But in March, Mr. Trump moved to oust Slaughter from her position at the FTC. Slaughter, however, sued, arguing that her firing was illegal because federal law limits a commissioner's removal to quote, instances of inefficiency, neglect of duty, or malfeasance in office. Lower courts ruled in Slaughter's favor and ordered her to be reinstated to her position. The Trump administration then sought emergency relief from the Supreme Court. In court filings, lawyers for the Trump administration argued that the modern FTC exercises vast executive authority, a change from the 1935-era commission. The Supreme Court and Humphrey's executors said Congress could insulate members of independent agencies from being removed without cause if that entity met certain criteria, including performing only quasi-legislative and quasi-judicial functions. In court filings, lawyers for the Trump administration argued that the modern FTC exercises vast executive authority, a change from the 1935-era commission. Well, as far as I understand, the extent of their executive authority that you think that they have as an agency isn't really important. That isn't meaningful whatsoever to the argument of whether you have the right to fire or hire this FTC commissioner or whatnot, the slaughter lady. To me, this smells almost like the made-up major questions doctrine, right? To me, it almost smells like that. Like they're almost trying to invoke that. Like they're basically saying like, well, we think that the agency has changed enough that you guys should, we think that they've grown too powerful and that you guys should just do something, right? Even though that I don't feel like them having vast executive authority or even if they could prove that their authority has expanded since the creation of the FTC, that has any bearing on whether the Trump should have the right to hire or fire its commissioners, right? It seems like it almost feels like they're trying to invoke the major questions doctrine in this, but this doesn't seem like I guess the major questions doctrine is just so broad and vague that they could use it for almost whatever they want. But it does seem like it isn't exactly super fitting for this. So I don't really know this seems like a very strange argument to make. Especially it's supposed to be coming from the lawyers, right? You think lawyers would make coherent arguments. Maybe I'm just misunderstanding it. I don't know. Solicitor General D. John Sauer argued that the FTC wields substantial executive authority like the other agencies whose members the president has been allowed to remove. Okay, that would make sense. So if they're arguing that, like, if that is the reasoning by which they gave that allowed him to remove members of other agencies, basically that the agency has grown too powerful and that therefore the rules regarding hiring and firing are disregarded and given exclusively to the president. First off, none of that legal reasoning makes any sense. But if they're arguing I'm not 100% sure, but if that is the reasoning that the Supreme Court gave for previous rulings just in the last few months about him firing other members of other agencies, then it would make sense that that same argument would apply to the FCC. The FTC is just another agency, unlike any, it's just like any other. So if that was the legal reasoning they give for which he could fire members of other agencies, it would make sense that they would give that same reasoning that he could fire members of this commission. Now, obviously, it makes absolutely no sense whatsoever. The extent of the power and authority of these agencies has no bearing on whether you think the rules that Congress put in place, with Humphrey's executor and whatnot, should be applied or not. I don't understand what the authority and extent of the authority of an agency has anything to do with Humphrey's executor. I don't understand. District courts cannot compel reinstatement of agency heads and allow them to purport to exercise executive power when the president has determined they should exercise none, he wrote. This is such a weird, funny statement. This basically is like, no, you can't. This is Trump's lawyers going, no, you can't. You can't do that. You can't do that. No, you can't. This is kind of funny. But lawyers for slaughter said that for the past 90 years, every president, including Mr. Trump during his first term, has respected the Supreme Court's finding that the for-cause removal requirement for the FTC is valid under the Constitution. The protracted and unanimous acquiescence of all three branches of government in the law at issue here, a law that affirmatively empowers the president to remove commissioners for good cause, defeats applicants' assertion that their continued adherence to that still binding precedent while their appeal is pending could cause them irreparable harm, they wrote in a Supreme Court filing. The Supreme Court issued this ruling in a Shadow-Docket emergency ruling. Now, slaughters, in theory, the Supreme Court has gone completely rogue in these last 8 months and has completely done away with the standard by which they used to issue emergency Shadow-Docket rulings. I'm trying to remember the precedent. It was called, I can't remember the exact name of it, but there's a name for the precedent. And the precedent is basically that, like, the government In order to receive an emergency stay and a shadow docket ruling, they have to prove that irreparable harm would be done if the court does not grant this emergency appeal, right? Does not allow them basically. In this case, the emergency appeal would be allowing him to go ahead with the firing and then deal with it later, right? Because in a lot of the times when you have a legal question like this, what will happen is Trump will try and fire this lady. It'll get kicked up it'll go to court. That'll get kicked up to the Supreme Court, and the Supreme Court will say, look, we don't know what we're not ruling on this for another 3 months. We're not going to see this until December. And so we're going to reinstate the lady. We're going to reverse your firing and basically put a pause on all of it until we know until we make our official ruling in December or however many months from now they decide to make that decision. And then you can potentially reinstate the firing or whatever the ruling would say. In theory, though, you're supposed to be able to prove that, okay, well, if you don't issue that emergency appeal, that they would, irreparable harm would be done.
Basically, they're making the argument that because Humphrey's executor has been the standard for over 90 years, and because it has been acquiesced and accepted by all three branches of government for over 90 years, that it is an ingrained part of the system, and that because of that, it's totally expected, they knew it was going to happen, and that they couldn't possibly make an irreparable harm argument.
And of course, in this case, emergency relief for the government results in Slaughter being fired. So obviously she doesn't want the emergency shadow docket ruling, relief to be given. She wants it to be, handled like a normal court case would be. And I think under a Democratic president and under most other times in our country's history, it would be. But because this Supreme Court has gone completely sycophantic towards Trump, they've completely lost their minds and have completely done away with the precedent that they previously used to determine shadow docket emergency rulings. What is the name of that precedent? NCAN. So the Supreme Court precedent regarding irreparable harm and shadow docket relief is typically, colloquially referred to as the NCAN standard, NKEN. Slaughter's legal team warned that if she could be fired by the president without cause, the FTC would be severely wounded and radically transformed. The Supreme Court's 90-year-old precedent provided a narrow exception to the president's removal authority, but the High Court has in recent years chipped away at that ruling. In 2020, the Supreme Court found that the structure of the Consumer Financial Protection Bureau, headed by a single leader, removable only for inefficiency, neglect, or malfeasance, was unconstitutional. Then, the following year, it ruled that the structure of the Federal Housing Finance Agency violates the separation of powers because it is led by a single director who could be removed by the president only for cause. Okay, I need to look more. This is a lot that they've dumped into this very last paragraph of this article. I would need to look more into, because they reference how they allowed the firing of the Consumer Financial Protection Bureau head, and the reason they gave was because there's only a single leader, right? And they also mention over here in the following year the structure of then the following year, it ruled that the structure of the Federal Housing Finance Agency violates the separation of powers because it is led by a single director. A connecting thread between the two is the single director thing, right? There only being one person to appoint to. Well, I wonder how that will affect the ruling for the FTC situation, because the FTC is a commission, right? A commission of 5 people. Not one. So I would think that some of their reasoning about like the agencies not being properly headed isn't really as applicable. So I don't know. We'll see where they go with this. It seems extremely dangerous. And I'm not saying that just because, obviously I don't care about whoever Slaughter is or this random lady that Trump appointed and Biden reappointed or whatever. I don't care personally if she loses or doesn't lose her job. It doesn't affect me personally. But what does affect me personally is the proper functioning of our government, having systems that are efficient and not antiquated, and recognize certain shortcomings in the way that our government is set up. And I think independent government agencies not being beholden directly to the president, not being able to be like politically swayed one way or the other just because they can is super important. And so this could be a very, very significant ruling, just as significant as the Chevron doctrine, how they basically have overturned the Chevron doctrine, or at least to some extent they have. I worry about Humphrey's executor in that if they were to go full out, absolutely, fully overturn it, then I wonder, I would think that if they do fully overturn Humphrey's executor, then I think the ball is in Congress's court to basically claw back all of that authority. Because if the Supreme Court rules that all of the authority from the top down, unequivocally, without question, 100% of these agencies goes to the president just by simple virtue of it being an executive agency, all of the rules and mandates and laws that the Congress put around this agency be damned, then I think it would be extremely important for Congress to claw back that authority, because then they have really just abdicated their authority to the president, right? In theory, Congress is like allocating, abdicating, mandating, whatever word you want to use. They're taking some of their authority and shifting it over to an independent government agency, an executive agency, right? In theory. And for all the reasons I gave at the beginning, right? You can't expect every senator to know the exact proper carbon pollution rates for a factory, okay? Yeah, basically Congress needs to claw back all of the authority from all of these agencies, and then we go back to pre-government agency U.S. government, to where Congress is expected to basically handle everything and also update all of the bills with all the science, and it takes us a humongous step backwards regarding governance, regarding efficiency, regarding basically any way that you would measure the United States against other countries.